Hello, this is the second video on international responsibility of states where I explore the concept of internationally wrongful act and attribution. As codified by the International Law Commission, the rules governing international responsibility are based on two main principles. States become internationally responsible when they breach any rules of international law that are binding to them, whether this is a customary rule, treaty law, a general principle of law, or a unilateral act. What matters to raise international responsibility is the existence of a breach of an international rule, whatever its nature. Even if a damage is not caused by breaching the rule, the responsibility of the state is raised by the mere existence of the breach, whatever the intent of the state. It does not matter if the state wanted or did not want to breach that rule. Conversely, even if damage is caused, there is no international responsibility if that damage comes from illegal behavior. As stated in a previous video, this statement must be nuanced by adding that certain treaty regimes establish responsibility of states for causing damage even if no legal obligation has been breached. For instance, the 1972 Convention on International Liability for Damage Caused by Space Objects establishes that a launching state must pay compensation for damage caused by its space object on the surface of the Earth. In any case, there is a general principle of law by which the state causing a damage must compensate. However, this does not mean the state is internationally responsible as a general rule, if no breach of international law exists. So again, what matters is that there is an internationally wrongful act. This is the element that needs to be met to have international responsibility, an internationally wrongful act. Second, for international responsibility to raise, the wrongful act must be attributable to a state. The link between the illegal act and the state must be found. Let's see this through an example. In the oil platform case that was submitted by Iran to the International Court of Justice in 1992, the Islamic Republic of Iran was claiming that the United States of America, by destroying several Iranian oil platforms in 1987 and 1988, had violated a treaty between them, the 1955 Treaty of Amity between Iran and the United States of America. In response to that claim, the US lodged a counterclaim alleging that it was Iran who had violated the 1955 treaty because Iran had attacked first different vessels in the Gulf and otherwise it had engaged in military operations against the United States. So in that scenario, the question became whether or not the United States had acted legally, attacking the oil platforms as in the exercise of the right to self-defense, that is, responding to a previous attack by Iran. Among other issues, the International Court of Justice concluded that the US could not prove that the attacks it was claiming against vessels in the Gulf were attributable to Iran. The US failed to prove attribution of the acts to Iran. I have reproduced here Articles 1 and 2 of the Articles on Responsibility of States for Internationally Wrongful Acts that codify the two main principles I have just explained. It is not always straightforward to establish whether an act can be attributed to a state. A state is an abstract entity, a legal fiction that acts through specific organs made of persons. The first thing to establish then is who can we consider acts on behalf of the state. And only then we can then establish which acts can be attributed to the state. The Articles on State Responsibility regulate the attribution for organs of a state, private persons either acting as public authorities or under control of the state, the acts of insurrectionaries, and what happens when an entity representing the state or acting on behalf of the state goes beyond the provided instructions or competencies, what we call acts ultra vires. Article 4 of the Articles on State Responsibility for Internationally Wrongful Acts reminds us that the conduct of any official organ of the state, of any entity, body that belongs to the official organigram of a state, is attributable to a state. Who is an organ of a state is a question that is answered by the domestic law of each state. You will normally find an executive branch, a legislative branch, and a judiciary. Any conduct by any of these bodies, for instance, passing a law that is contrary to a treaty obligation, is attributable to the state and can raise international responsibility. For these organs that belong to the official structure of the state according to national law, even acts ultra vires are attributed to the state. Acts ultra vires are those that are performed by someone who lacks authority, either if she goes beyond what was instructed or if she goes against what was instructed, or because that person body simply lacks competence to carry out these specific activities. For instance, in the armed activities in the Congo case, a case that's between the Democratic Republic of Congo and Uganda, over violations by Uganda in the territory of the Democratic Republic of Congo, the International Court of Justice determined that any act of the military of one state is attributable to that state with independence of whether or not the military has acted beyond orders. Even if the military is acting against specific instructions, this act can be attributed to that state. Acts of private persons can also be attributed to a state if the person body was acting in exercise of a governmental authority. As long as it acts in that capacity, the acts of the individual entity are also attributed to the state. For instance, many times states will hire private bodies to exercise public duties, and in performing these duties, they might violate international law. In practice, the distinction between private and public bodies, private and public functions can become very complicated. As a main point to take from this, acts of organs of states are attributed to the state because they belong to the structure of the state, in whatever capacity they are performing their activities. The conduct of other entities not belonging to that structure might be attributed to the state if the law provides them with governmental authority, for instance, private entities developing military functions, and here their conduct can be attributed to the state if they are performing the public function assigned to them. The attribution is functional. It depends on whether the entity is performing that function at the time the breach of international law happens. During that time and on that function, conducts that excess authority or go beyond what is authorized are also attributed to the state. For instance, if a state hires private bodies to act as police and the police arrest illegally the representative of another state, the acts of the private body acting as police is attributable to the state, even if they have acted without authorization. Acts of insurrectional movements, mobs, can also be attributed to the state when the movement becomes a representative of the state, that is, when it succeeds in its insurrection. So an illegal or a non-state armed group that organizes a coup d'etat and becomes successful will become also responsible, will have international responsibility for violations of international law that happened while it was an insurrectional group, but only if it becomes later on part of the state. The state is normally not responsible for damages caused by mobs or insurrections or civil wars in its territory that may cause, nonetheless, damage to another state or international organization, unless it does not do what is in its hands to prevent or stop the damage, or if it endorses the action that caused the damage. We'll see a bit more about this in a minute, when looking at the kind of conduct that may raise international responsibility. But the main idea is an insurrectional group might become internationally responsible for violations of international law if it becomes a representative of the state. However, the state is not normally responsible for damages causes for civil unrest within its territory that might cause some kind of negative impact in a third country. Article 8 tells us that a state is also responsible for acts conducted by others if they are acting under its direction or control. What acting under the instructions or control of a state means was established by the International Court of Justice in 1986 in its judgment on the Nicaragua versus the United States case. This case relates to a series of interventions by the United States of America in Central America and that were aimed at implementing the so-called Truman Doctrine of Containment. Within the geopolitical coordinates of the Cold War, this policy consisted in intervening in third countries to stop the spread of socialism and therefore the spread of the area of influence of the Soviet Union. After the Sandinista revolution that overthrew the right-wing and pro-American dictator Somoza at the end of the 1970s in Nicaragua, the United States actively supported the opposition group that was known as La Contra, with the aim that they will re-establish Somoza in power. Nicaragua took the United States to the International Court of Justice, alleging that the United States in recruiting, training, arming, equipping, financing, supplying and otherwise encouraging, supporting, aiding and directing military and paramilitary actions in and against Nicaragua, I am quoting, was violating international law. One of the main issues the court had to adjudicate was whether the activities of La Contra could be attributed to the United States. The court decided a very high threshold and established that for attribution of the acts of La Contra to the United States, the United States needed to have effective control of La Contra. I have reproduced here paragraph 115 of the judgment, which is possibly one of the most cited in international law textbooks, so you can read it yourself and see how the International Court of Justice articulated the principle. This is obviously of great relevance when deciding the responsibility of states for many other scenarios, where states support specific opposition groups within a territory that may themselves violate international law. For instance, several European countries have supported opposition groups in Syria against Assad. According to this test, if the opposition groups supported by the Europeans went on to violate international law, these breaches cannot be attributed to the European states supporting them unless they had full effective control on the operations leading to the violations of international law. To be more specific, the British press reported, for instance, a couple of years ago that the United Kingdom was funding a scheme aimed at supporting an armed Western-backed Free Syrian police force. But this money was diverted to jihadists linked to extremist groups. In a more interventionist move, the USA also launched the Syrian Train and Equip program in 2014 that identified and trained Syrian opposition forces to return to Syria to fight ISIS. The effective control test means that violations by the trained groups by the USA or the funded groups by the UK cannot be attributed neither to the US nor to the UK. The violations that these groups might perpetrate cannot be attributed to the UK or the US. A different court and in a different context, the International Criminal Tribunal for the former Yugoslavia used a less stringent test and affirmed that it was sufficient for a state to have overall control instead of effective control of a group to attribute the actions of the group to the state. However, the International Court of Justice reiterated the need of effective control in the case concerning the application of the Convention on Genocide in 2007. Therefore, according to the International Court of Justice, the test of effective control prevails. Please remember that we are looking at the rules governing responsibility of states in general international law. In specific areas of law, such as investment law or human rights, the rules of attribution are more flexible or differ slightly in the topic of attribution. For instance, in the field of human rights, the discussions on attribution are especially controversial for violations of human rights happening outside the territory of a state. In 2017, the Inter-American Court on Human Rights decided in an advisory opinion that a state could be responsible of damages suffered by another state in its environment if the responsible state had effective control over the origin that caused damage. For what concerns the general rules of international law on state responsibility, as far as we are concerned, the effective control test remains in force. States can breach international law by doing something that breaches international law, but they can also breach international law by doing nothing. The determinant factor is whether the action or omission has resulted in the breach of an international rule, whether or not an international wrongful act exists. It does not matter if the rule that has been breached is a customary rule, a treaty, a general principle of law, or a unilateral act. Many International Court of Justice cases, for instance, France was found in breach of its obligation not to perform nuclear tests in the Pacific by carrying them out after promising not to do so. Hungary has been found responsible for not building the part of a dam it had obliged itself to build as part of a 1977 treaty with Slovakia, then Czechoslovakia. In the Lagrand and Avena cases, the United States has also been found responsible for violating treaty and customary law because it sentenced to death foreign nationals from Germany and Mexico without offering them consular assistance. We see here, therefore, another case of omission that constitutes a violation of international law. The general principle of law of due diligence imposes obligations of prevention on states for damages to other states. In practice, it is difficult to articulate the specifics of the obligation in general, but it has been codified in several treaties, and it has a particular meaning in some areas of international law. The obligation of due diligence has been especially developed in the field of environmental law and in treaties protecting the environment. However, there are other examples. In a 2015 report of the International Law Commission, there is a list of all treaties that have as one of the main objects and purpose the codification of the obligation of prevention in international law and in the specific area they codify. We can cite here the Convention on the Prevention and Punishment of Genocide as applied by the International Court of Justice on the case between Bosnia and Herzegovina versus Serbia and Montenegro in 2007. In the context of the prohibition of torture and the protection of refugees, both customary law and treaty law impose the obligation known as the obligation of non-refoulement. That is, the obligation that by which states cannot return a person to a country where they are at risk of being subject to torture or persecuted. This is clearly an obligation aiming at preventing a violation by a third party. It seems pertinent to mention the international health regulations of the World Health Organization, ratified by 196 states and in force since 2007. It contains specific obligations to prevent infectious disease threats such as the current pandemic. In a case between Argentina and Uruguay over transboundary damages, the International Court of Justice clarified the general obligation of prevention and the content of the obligation of due diligence. I have reproduced here the relevant paragraph of the case for you to read. Finally, a state may become responsible for acts conducted by third parties if it endorses the behavior. The typical example is the Iranian hostage crisis, where the Iranian government breached international law by omission and by endorsement, as well as by failing to prevent the concerned violations. This happened when a group of students and other militants whose actions could not be attributed directly to the Iranian state took over the US embassy in the capital of Iran, Tehran. The acts of these groups were attributed to the Iranian government for failing to prevent the attack, stop it, or for failing to oblige the militants to withdraw from the premises and release the hostages. In addition, some organs of the state at the time endorsed the acts and helping to perpetuate them. So the International Court of Justice considered that all these omissions plus the endorsement transformed the acts of the militants into acts of the Iranian government. I highly recommend the film Argo if you want to know a bit more about this crisis in an entertaining way. Finally, a reminder that the International Law Commission has also codified as special international wrongful acts those violating peremptory norms of international law or the so-called obligations erga omnes. I have already said in the first video on the topic of responsibility that the inclusion of these categories crystallizes the constitutionalization of international law and introduces core principles that go beyond an understanding of sovereignty exclusively based on consent. We have also explored the concept of peremptory norms when we saw sources of international law, and we will see more about erga omnes obligations when we explore the rights that are born for the injured states when an international rule is violated. That will happen in our next video on state responsibility. We will also examine obligations erga omnes further in the context of the Gambia versus Myanmar case, for which Professor Shebas has recorded a couple of videos as the basis of the live session with him. The list of the leading International Court of Justice cases addressing peremptory norms and erga omnes obligation has also been included at the end of the first video.